So today we're going to be taking a look at this topic here, when to release clinical notes to court. So let's go ahead and take a look at two test prep questions to get familiarized with some of this terminology. Hello and welcome back to my channel, Mental Health with Melissa. I'm Melissa. If you're new here, please don't forget to hit that like and subscribe button for more content like this. I post new videos every single Sunday and Wednesday, and subscribing to my channel really helps me get mental health information out there to our communities of color and tons of free LCSW test prep information and questions. I am a therapist, an LCSW clinical supervisor, and PhD psychology research student. So today we're going to be taking a look at this topic here, when to release clinical notes to court. So let's go ahead and take a look at two test prep questions to get familiarized with some of this terminology. If you're new here, please pause the video, read the question and answer it, and then play it and then compare and contrast your answer to my rationale so that you can kind of test your test-taking ability. A therapist at a private practice receives a phone call from a lawyer stating one of the therapist's clients is in a major court case and requests the client's case notes from therapy as soon as possible. What is the best response from the therapist? Okay, so we see here that there's a therapist at a private practice, receives a phone call from a lawyer stating that a therapist client is in a major court case and wants some of the records from therapy. So what is going to be the best option? And if you've watched my other videos, best is a key word here because that means that there may be multiple responses that may be pertinent and that could be the answer, but we're not looking for all of the responses or what is closest to the best. We're looking for the best response. So let's go ahead and take a look at the options. Option A, release information to the attorney as requested to comply with the law. So hopefully by this point you have read some material on confidentiality and when you can or when you cannot release information. And this right here is not a strong answer, and I'm going to tell you why by looking at the other options first. So option B, assert privilege and notify the client. So what does assert privilege mean? Because if you're a social worker or a therapist new to the field, this may look like a pretty new type of term that is associated with legalities. And so we want to learn exactly what this means. So privilege is a legal term, so it is a legality type of terminology that's related to issues of confidentiality. So usually when a lawyer reaches out to a therapist and the lawyer subpoenas notes from that therapist or wants to confirm that the client is receiving therapy from that therapist. As a therapist, you have the right and the legal notion to assert privilege, because at this point, what we've kind of learned in looking at some of these study materials for the LCSW test is that you do not break confidentiality if you receive a subpoena from an attorney or a lawyer. You want to maintain the confidentiality by asserting the privilege. So this is a key term here, asserting the privilege and letting the client know. So at this point, it would not even be appropriate to confirm or deny that the client is actually receiving services from you, or to even, confirm or deny that you know who this person is. So you would just say assert privilege, and then you would want to let the client know right away. So, because I kind of just gave you the answer, we're going to go ahead and cross out that first option. Option A, release information to the attorney as requested to comply with the law. This is just wrong based on the information that I just gave you. Option A is going to be incorrect. Option C, inform the attorney the client is indeed in therapy with you. However, state the case notes will have to be reviewed prior to sending. So just based on the information I gave you a minute ago, this is also wrong because, like I said, you can't confirm nor deny that the client is indeed with therapy with you or not. So that would be wrong. Option D, ask the attorney to send a release of information from the client and then the case notes may be sent. So while this may be certainly an option after this best and first option, it's not going to be the best and first thing that you do. So again, what you're going to want to do is assert privilege. Again, not confirming or denying that you know this client or that they are a client, and then let the client know as soon as possible. Because, again, a subpoena from a lawyer is not a requirement for you to actually break confidentiality. Okay, let's look at this second LCSW test prep question. A therapist at a private practice receives a court order for a client's case notes. The client believes this will cause, the therapist believes this will cause extreme emotional distress for the client. What is the best response from the therapist? Okay, so again, we're looking at this keyword here, best. So option A, assert privilege and notify the client. Okay, so while this option would work like it did in the question that we looked at previously, because it was a subpoena from an attorney, this would not work if there's a court order or a judge order for a client's case notes. You can only assert privilege if it's a subpoena from an attorney. So if a court orders or a judge orders that they have the client's case notes, you have to be willing to give them up. So because of that, this would not be appropriate. Option B, deny the court order. So just again, based on what I said, you can't deny the court order. A court order is an order from a judge, and that supersedes any sort of subpoena from an attorney. So you do have to comply with the courts and the judge. So that would not be the answer. Option C, ask to speak with the lawyer. This is very irrelevant at this point because, again, the court and the judge, they supersede anything that has to do with a lawyer. So you could ask to speak with a lawyer, but they're still going to want those case notes in the first place. So that's not strong. So that's not going to be correct. Lastly, option D. Based on the process of elimination, we've come to our answer, but let's figure out why. Option D, provide case notes as ordered and file a waiver endorsing the therapist's concerns about the client's well-being. So this is going to be your option because, again, you do have to provide those case notes as ordered by the court. However, you can still file that waiver because you know, clinically speaking, that this could cause significant harm to your client, and you want to do everything in your due diligence to obviously first and foremost protect the client. Thank you so much for watching. Please, again, don't forget to hit that like and subscribe button for more content. And if this video was helpful, please leave a comment in the comment section below, especially if you have any video requests. I'd be happy to take a look and get those going. Until next time, managing mental health matters.